All right, so again, you are here for the New Landowners virtual series. Tonight we're going to talk about agriculture law, landowners assistance opportunities. Our first speaker is going to be Tiffany Dowell-Lashmet. She is an associate professor and extension specialist in agriculture law, and she actually did a pre-recorded presentation for us. So technology willing, I'm going to get that started. Then we've got a guest from the NRCS office who's going to speak, a guest from the FSA office. She actually wasn't able to be here, so I'm going to talk a little bit about Farm Service Agency a little bit later. And then the two agents that are here, we're going to discuss a little bit more about what extension does if you needed to know any more about that, or if you have any questions, we're going to entertain those as well. Okay, so give me one moment and let's make sure we can get this pre-recorded talk working.
Hello, my name is Tiffany Dowell-Lashmet. I'm an extension agricultural law specialist.
We good, Matt?
Yep, we're good.
Okay.
And I appreciate the opportunity to be with you to discuss some key legal issues for new landowners in Texas. We'll kick things off by me telling you that we are very much going to just do a kind of a Cliff's Note version of the presentation tonight. I have a in-person course that we do called Owning Your Piece of Texas, Key Laws that Texas Landowners Need to Know. That's about a 6-hour class. I'm currently working on turning that into an online course and covering even more topics. That's going to be about 13 hours worth of content. So as you can imagine, we're very much just hitting the high notes in our hour that we have together today. We'll start off with a disclaimer, and that simply says, I'm a lawyer, I'm not your lawyer. So I can't give anybody specific legal advice, and the materials that I present today are strictly to be for informational purposes only. So here's a roadmap of what we're going to plan to cover. The first topic we're going to look at is the importance of having liability insurance. If you don't do anything else kind of as you leave the program today, I think that's the most important.
Hey, Casey, you got muted.
We're going to talk about a very popular topic, and that's image.
Okay, I see that. That's weird. I'm going to back it up about 10 seconds.
If you're typing, I think you can be typing on your computer too.
The second issue we're going to look at is some limited liability statutes that exist here in Texas, and a lot of landowners aren't aware of the protections those can afford in the event that someone is injured on your property. Third, we're going to talk about a very popular topic, and that's eminent domain. My advice on that tonight is simply going to be, don't just sign what they give you. We'll talk a little bit about why that's important and some of the procedural issues you need to be aware of. And then we'll wrap things up talking about a fence law issue, and that is, are you in an open range area or a closed range area? That's really kind of a linchpin to analyze any sort of fence law issue that you may be facing. Okay, so let's start off and talk about why you need to make sure if you own land, you have liability insurance. Every landowner needs to have this, period. No ifs, ands, buts, excuses. This is a protection that every landowner needs to have. And keep in mind that insurance, liability insurance, actually provides you kind of two benefits. I think we all understand that one of the main benefits of liability insurance is that you've got this coverage up to a certain policy limit, and for any claim that falls within the scope of the policy, the insurance company will pay up to that amount for damages. Don't forget, though, that the second benefit of insurance is that the insurance company will provide you a defense in the event that there's a claim made under the policy. What that means is the insurance company is going to hire a lawyer on their dime to represent you in any sort of lawsuit. Breaking news here, right? Lawyers are expensive. So having the insurance company be forking over the money for that bill is a really big benefit that you have simply by carrying liability insurance. Another thing on liability insurance is generally not that expensive. Now, you may think, Tiffany, I saw our insurance bill last year from whatever company. You're wrong. Here's the kicker. If you looked at your insurance bill, you probably were looking at property and liability coverage together. So you had a total bill. If you look just at the liability section of that policy, it's generally not that expensive. So, for example, my husband and I own a half section of land here in the Panhandle. We've got $500,000 in liability coverage on that property. I want you to guess how much we pay per year to have that liability coverage. About $100, right? So the idea that you could have $500,000 in coverage and basically a lawyer on speed dial that your insurance company is going to pay for, make paying that $100 certainly seem like it's money well spent. How much insurance do you need? It really depends on what you're doing. I like to think about this kind of as a totem pole. So one example is the property I just mentioned. It's kind of in the middle of nowhere. We don't have hunters there. We just run our cows. We're not on a major highway. All right, so our risk is low, right? We're low on the totem pole. We have insurance. We just don't have super high coverage because we don't have super high risk. Flip that and let's think about last fall, I took my kids to a pumpkin patch. It was a lovely time. All I could see were potential liability pitfalls everywhere I looked, right? You've got the kids running around in a pumpkin patch with sharp objects to cut the stems, and there's, foliage all over the ground, and there could be snakes and bugs and who knows, right? Their risk is much higher than ours, and so they're going to be much higher on that totem pole of what insurance they need. And so this is where you can really work with an insurance agent, hopefully one that understands agriculture, to help you analyze your risk and get you the exact coverage amount that you need. As far as what insurance company to use, I don't care. Frankly, as long as you've got good coverage, that's what's most important to me. I will say I do like companies where you've got either a company or at least an agent who understands agriculture, just because I think that's important when you're trying to analyze those potential risk issues that could come up. Okay, the next thing you want to do when you're looking at an insurance policy is make sure that every activity you have going on is covered, right? So if you've got a farm and ranch policy and you're raising cows, that's probably fine, right? That's going to be covered. But what if you decide to expand your operation and you decide to rent out your cabin to hunters, or you decide to start selling some of your farm products on the side of the road, right? As we expand our operation, we need to be really careful to make sure that our insurance coverage is expanding with us, because we don't want to get in a situation where we thought we had insurance and it turns out we didn't have it for that specific topic. Again, that's an area where being in good communication with an agent is really important. The last thing I'll mention on insurance is you want to watch for any caps on coverage in the fine print. One place that I've seen this pretty frequently in farm and ranch or ag type policies is when it has to do with pesticide drift. So I've seen $1 million farm and ranch policies that have a special provision that will say coverage for pesticide drift is capped at $2,500. Or I've seen one that says that pesticide coverage is only available for ground application, not for aerial application. So make sure you watch those, any sort of exclusions or limitations that are in your policy. One last issue that I'll bring up, just because I get questions on this pretty frequently, is the topic of umbrella insurance. So sometimes people will say, right, I understand all of this, but I don't have to worry because I have an umbrella policy. I hate the name umbrella. Policies are fine. It can be a great way to add additional dollars of coverage. The problem is when we think of an umbrella, we think of an object that covers everything. And that kind of gives us a false sense of security, because what an umbrella policy does is it sits on top of an already existing liability policy. So if we've got a liability policy in place, that spells out the scope of coverage, right? Is this activity covered or not? That's all spelled out in that policy. What the umbrella does is it sits on top of that policy to increase the dollar amount of coverage, right? So maybe you have a $500,000 $500,000 policy, and that sets out the scope of coverage. Then you buy a $2 million umbrella. It sits on top. It raises your coverage amount from $500,000 to $2 million. What it doesn't do is add additional scope, right? It doesn't now include that, hunting cabin that we talked about earlier. That's not included just because you have an umbrella, because the umbrella just adds dollar amount of coverage. So I wish it was called a top hat policy, right? Because it sits on top of the other policy. So just keep that in mind. Again, I'm certainly not against an umbrella policy. I think that could be a great way to cheaply add additional coverage. Just make sure you understand the limitations there, and that's not some sort of, be-all, end-all product. Okay, the second topic I want to touch on has to do with limited liability statutes here in Texas. There are actually 3 statutory provisions that the legislature has enacted aimed at providing limited liability or providing additional liability protections for agricultural landowners. These are really kind of one of the best kept secrets, I feel like, in ag law, because a lot of landowners, even long-time landowners, aren't aware of these statutes. So today we're going to just kind of, again, hit the high notes, make sure you're at least aware of these, so you can go study up on them and take the steps you need to make sure that they apply to your operation. The first statute we'll talk about is my favorite. It's called the Texas Recreational Use Statute. You can find that statute at Texas Civil Practice and Remedies Code, Chapter 75. And essentially what the statute says is that if you open up your private property to someone for recreational purposes, we're going to limit your liability. In other words, we're going to make it more difficult for someone to be able to successfully sue if they are injured on your property, if they're there for a recreational purpose. And the way the statute does that, it basically says that a person who's injured cannot sue successfully for negligence. We're going to just protect that. You're not going to be sued for negligence. In order for there to be a claim made, right, in order for the landowner to be liable, an injured party would have to prove intentional acts or gross negligence. That's a much higher standard than the traditional negligence analysis that we would see in these type of cases. So again, it just sort of changes the proof that has to be made in favor of the landowner. So let's say that you've got a hunter out on the property and they get injured while they're hunting. They can't succeed on a claim by just proving you were negligent, right? Instead, they're going to have to prove that you intentionally injured them or you acted with gross negligence. And that's going to have to be some action that was really egregious, something that sort of shocks the conscience and shows a conscious disregard for human life. Very difficult standard for a plaintiff to prove. Okay? So in order to get the protections of the recreational use statute, there are 3 requirements you're going to have to meet. The first one is the land needs to be agricultural land. Now, side note, some provisions of the statute apply to non-ag land. We're not going to get into that today. So we're just focusing on the ag land portion here, but just be aware it actually can be broader as well. So if the land involved is agricultural land, that's the first step. And agricultural land is defined as land that is suitable for growing crops, grazing livestock, or forestry. Suitable for. Doesn't say you have to be doing those things, right? And so for me, when I analyze this, I always think to myself, could a goat live there? The answer is almost always yes, right? Goats can live anywhere. And so it's a very broad definition of what is agricultural land. So that's the first requirement. The second requirement is that the plaintiff had to be there for a recreational purpose. One that most people are concerned about is hunting, and that is included in kind of a long litany of activities. Hunting, fishing, hiking, biking, bird watching, riding four-wheelers, swimming. And then it says at the end of this list, any other activity associated with nature or associated with enjoying nature and the outdoors. Again, that's pretty broad, okay? So you've got a recreational user on agricultural land. there's one more requirement you've got to meet to get the protection of this statute. And that's going to be a monetary requirement. You've got 3 options under the statute. You only need to meet one of them. The first option is if the landowner does not charge a fee. So let's say you let your neighbor come and hunt for free on your ranch. We've got ag land. We've got a recreational use. You did not charge a fee. That means the statute applies, right? You're only liable for intentional acts or gross negligence, thanks to this statute. Pretty great, right? You don't have to do anything to make it apply. You don't have to file paperwork or hang up signs. It just applies. So I think that's really a great benefit of the statute. So again, you have 3 options on the monetary prong. You cannot charge a fee. Or if you want to charge a fee, the statute says it applies if the total charges for the past calendar year for all recreational users is less than 20 times the amount of ad valorem taxes last year. In English, what that says is you're going to get a piece of paper and you're going to add up all the money you made last year from recreational users. Anybody who paid you to hunt or fish or hike, whatever, get a total. In another column, you're going to add up all the property taxes you paid last year anywhere in Texas. Okay, not just the property where you've got recreational users, but any property you own, including, like houses in town. Get a total. As long as the income number is not more than 20 times higher than the property tax number, the statute applies. Almost everybody fits there. You have to make a lot of money for recreational uses for that not to work. Okay, and here's your third option. If you carry liability insurance of at least $500,000 per person, $1 million per occurrence, and $100,000 for property damage, this statute applies to you regardless of how much you charge. All right, so that's great, right? If you have that level of insurance or higher, the statute applies. The other thing that particular option does for you, if you have that level of insurance or higher, the statute will impose a cap on damages that can be recovered. In other words, a person who's injured on the property for a recreational purpose cannot recover more than your insurance limits, which really protects you from having to pay out of pocket. So because of that, if you're going to have recreational users, I would really recommend to have at least that amount of insurance or higher in order to have that additional protection afforded by the recreational use statute. Okay, our second statute is called the Texas Agritourism Act. You're going to see that this is going to overlap quite a bit with the recreational use statute. And they're similar, but they're 2 separate legal protections. So there are some situations where both might apply. There are some situations where it would only be one or the other, and our best bet is to have the option of both. So I always tell people, I want you to basically have this folder of potential defenses you can hand to your lawyer if something ever happens. And so the Agritourism Act is another sort of tool that can be in that folder that you will handle. This statute's fairly new. It was just passed back in 2015. And what it says is an agritourism entity is not liable if a plaintiff is injured on agricultural land and they're there for either a recreational or educational purpose, if a landowner has either hung up a sign or obtained an Agritourism Act release. Okay, so let's kind of walk through these terms. We'll see who it applies to. An agritourism entity is defined as a person engaged in the business of providing an activity on agricultural land for a recreational or educational purpose regardless of compensation. That's extremely broad. Basically, if you've got agricultural land and there are recreational or educational activities happening, the statute can apply. Right? So this isn't just for like corn mazes and pumpkin patches. This can be for your ranch where you've got hunters because of that broad definition of agritourism entity. It applies if the plaintiff's on agricultural land. It's that suitable for test again. And this time it has to be suitable for growing crops or raising livestock. For some reason, it's suitable for forestry, is sufficient for the recreational use statute, but not the Agritourism Act. I'm unclear why, but be aware of that small difference. And then as far as what a recreational purpose has to be, it's that same definition of the recreational use statute, hunting, fishing, hiking, biking, that we already talked about. Additionally, do note that the Agritourism Act does offer you some protections for educational users as well. So potentially if you had somebody out for a field day or you had a school group out or something like that, their activity, if it was educational versus recreational, would be covered under the Agritourism Act, whereas it may not under the recreational use statute. Okay, so for this statute to apply, there's an extra step that you have to take. You have to either hang up an Agritourism Act sign or you've got to get an Agritourism Act waiver. So the sign has to be posted at a location that's clearly visible at or near where the activity is conducted. I just copied and pasted that language right from the sign. You can see a picture of a sign that was actually at Pumpkin Patch, I mentioned earlier. And it's just that you can buy those. A lot of groups sell them. Texas Farm Bureau has them. Texas and Southwestern Cattle Raisers, Sheep and Goat Association, Texas Wildlife. So there's lots of groups that you can purchase those signs. Or you can make your own. As long as you've got the language on there, there's no magic as to where you've got to obtain the sign. Okay, the other option, you can either hang up a sign or you can get an Agritourism Act release. That has to be signed before the activity by the participant or their parent, guardian, or managing conservator. It needs to be separate than any other agreement, so don't put that in your hunting lease. It needs to be a separate piece of paper that they sign, that the letters at the top say Agritourism Act waiver or something. It needs to be printed in not less than 10-point bold font. That's what the statute says. And here's the language. Again, I copied and pasted it right from the statute. You can have this printed on your paper, have your recreational or educational users sign that. You can do either one, the protection, the sign, or the waiver. I like things about both. I like the sign because you can hang it up and forget about it, right? You don't have to worry about chasing people down to make sure that they sign the waiver. The one place that I like the waiver better is if you're going to have minor children on your property. And without getting too far in the weeds on this, there's some question under Texas law about whether a general liability waiver is applicable if it's signed by a parent on behalf of a minor. The Supreme Court's never ruled on that. But there's some lower court opinions that have said they don't think that those releases will be enforceable. But if you look at this statute, it specifically says it can be signed by the participant or their parent, guardian, or managing conservator. That looks like pretty good evidence to me. The legislature intended this release to be able to waive claims for minor children. So I would just keep that in mind. If you're going to have anybody under 18 on your property, I think that getting this waiver signed by a parent is a really important step that you should consider taking. Okay, lastly about the Agritourism Act, there's a list of exceptions. We're not going to go through these because there's no case law on them yet. What I would say to you is let the lawyers fight about the exceptions. I would spend the $5 or $10 it costs to hang up the sign and at least have the option for that to be an argument your lawyer can make. Okay, the last statute that we're going to mention is called the Texas Farm Animal Liability Act. This was previously called the Texas Equine Act. You may remember an older statute. And it was expanded in 2011 to include not only horses, but also other farm animals like cattle, sheep, goats, hogs, etc. What this statute basically says is that a person is not liable for damages to a participant in a farm animal activity if the injury results from an inherent risk of participating in the farm animal activity. I think the best example of this is to think about, right, if somebody comes over to your house and you put them on a horse and they end up getting bucked off, that's going to be an inherent risk of riding a horse, right? You could get bucked off. And so this statute is designed to step in those situations and offer a defense to the horse owner or the farm animal owner that says, hey, this injury happened. It was an inherent risk of the activity. Basically, we're really sorry, but dismiss the lawsuit because this statute protects us. Okay? So if you're just kind of a regular person that has farm animals, you don't have to hang up any sort of sign. The statute just automatically applies to your farm animal activities. And again, if the injury is caused by an inherent risk. If you're a farm animal professional, you actually do have to take the extra step of hanging up a sign. I'm going to read this definition here. A farm animal professional is a person engaged for compensation in instructing a participant or renting to them an animal, equipment, or tack, or who provides veterinary or farrier services. So again, if you're somebody who's giving riding lessons, right, someone's paying you, you're a farm animal professional, you're going to need to hang up this sign to get the protections. If you just own horses and let your kids' friends come and ride, you don't have to have the sign. Okay? The sign needs to be hung up where you conduct the activity. You need to include it in all of your contracts. And here's the language that's included. Again, I know that Texas Farm Bureau sells those signs. Other groups probably do as well. I'm sure you can do some Googling and find them. There is a list of exceptions to the Farm Animal Liability Act that I want to walk through. One of the exceptions that's not listed in the statute, but was recently subject of a Texas Supreme Court case, is that the Texas Supreme Court recently held this statute does not apply if the injured party is a ranch hand or a rancher. And this came about in a case where an employee of a ranch was killed when he was moving a bull. His family sued the ranch owner, essentially claiming negligence and negligent training of the employee. The family moved to dismiss under the Farm Animal Liability Act, and this ended up at the Texas Supreme Court. And the court said that where the injured party is a ranch hand or a rancher, the statute doesn't apply. That's not what it was intended for, was the court's opinion. There was a strong dissent written by a couple of justices who basically said, hey, the statute says, any person is not liable, and we don't understand the distinction that you're drawing. Regardless, at this point, that's where the law stands. So this is not going to protect you if your ranch hands are injured, still applicable generally to other participants in farm animal activities. A few statutory exceptions that I'll mention. If the injury was caused by faulty equipment or tack, and the owner knew or should have known it was faulty, they can be liable. I think that makes sense, right? It doesn't strike me as an inherent risk of riding a horse that somebody gives you a saddle with a busted cinch, for example. This one worries me a little bit. This exception says, the defendant provided an animal to the person and did not make a reasonable and prudent effort to determine the ability of the participant to safely engage in the activity and to safely manage the animal. In other words, before you stick somebody on a horse or you stick somebody, in a pen of cattle or whatever, you need to do some questioning to figure out what experience they have, think about what horse you're putting them on, kind of do the best you can to ensure that there won't be a problem. So just keep that in mind. You could be liable if the injury is controlled by some sort of latent condition on the ground that you were aware of and you didn't warn about. So I see that coming up like in maybe the trail ride context. If you know there's some sort of big giant hole or something that's hidden, you need to make sure that you inform people about that. If you act with willful or wanton disregard of safety, if you intentionally cause the injury, of course, you can be liable as well. Okay, so on to our next topic, and that's going to be eminent domain. This is a topic I get tons of questions on because, frankly, there's just a lot of eminent domain projects going on around the state. And I think that this is an area where until you have dealt with this personally, you may not understand the law, and it can be really frustrating to learn about it from the landowner perspective. So, again, hitting some very high notes here today. Eminent domain is just the power of the government to take private property for public use upon the payment of adequate compensation. So there's sort of three prongs to this. The first one is the person who takes property has to either be the government or a private entity acting on behalf of the government. And I'll be straight with you, that's where we see a lot of frustration for people, right? We may not like it, but I think we all know that, TxDOT can come in and decide to build a road and take our property to do that. Where I think people get more upset is when it's a private entity who has government power to do it. So maybe that's something like a high-speed rail, for example, right? And there's still a legal question about whether that high-speed rail has eminent domain power, but that's just an Pipelines are another one. If you've got a pipeline company claiming eminent domain power because they're a common carrier, equally frustrated because it's this for-profit company taking private property. Okay, but again, it can either be the government or someone who the government has given that authority to. The taking has to be for public use; it cannot be for private gain. And the landowner is entitled to adequate compensation, which essentially is they're entitled to the fair market value of the property that was taken. In addition, I just wanted to throw this term out there so that you're aware of it. Landowners are also entitled to what's called remainder damages. And that basically says if they take an easement on my property, let's say it's a 30-foot easement, if that decreases the value of the remainder of the property that they didn't take, I should be compensated for that damages to the remainder. So that's something to be aware of when you're looking at those damages. Let's talk about common carrier pipelines. Again, this is one of the areas I get the most questions on. I think that people are kind of the most frustrated because you do have a private for-profit company who's coming in and is able to use the power of eminent domain. And that's because under Texas law, courts have said that a company that owns or operates a pipeline that transports oil products, gas, coal, carbon dioxide, or other mineral solutions for hire is a common carrier pipeline, and they have the power of eminent domain. The key there is that it has to be for hire. The pipeline has to be willing to, or there has to at least be the reasonable probability that the company is going to rent out space in that pipeline to someone other than themselves. Okay, so let's just say that there's going to be a pipeline that goes from Northeast Texas to Dallas. If the only company that's going to use that line is the company that built it, that is not a common carrier. Okay, that would be a private pipeline, and eminent domain is not available. If it's a pipeline where you've got multiple users are going to put product through that line, right? The builder is essentially like renting out space in the pipeline or renting capacity. Now you've got a common carrier pipeline. That's where Texas law says this is a public use, and they've got the right of eminent domain. So certainly, anytime you're dealing with a pipeline, the first question you need to ask is, hey, are you a common carrier pipeline, right? And then you need to do some investigation to see if what they tell you is accurate. The first thing that I would do if you're looking to see if they have eminent domain power is check. The comptroller has a database of companies with eminent domain power, on their website. I would check there. I would ask them to see a copy of the T4 that they filed at the Texas Railroad Commission. In order to be a common carrier, you've got to file this form at the Railroad Commission. And you don't have to provide a lot of information, but you do have to provide at least some detail, paperwork, affidavits, sort of explaining why you qualify as a common carrier. You can try to get a copy of that information from the company. You can ask questions about the project. You certainly can consult with an attorney to get their opinion or see what information they may be able to dig up as well. If you think that they're wrong, right? If you think that there's a case where the company came in and says that they had eminent domain power and you don't think they did, a landowner does have the right to challenge that declaration in court. In fact, I just did a blog post on a case from the First District Court of Appeals down in Houston, where a landowner successfully made that challenge and said, look, we don't think this pipeline is a common carrier. We don't think they have eminent domain power, and we're going to legally question that. And the Court of Appeals sided with the landowner and said, yeah, there's a question here. We're not going to grant summary judgment to that company. So that's a challenge that can be made. So if you end up in one of these situations, what will happen is usually you'll get a letter in the mail or a knock on the door, and they say, we're working on this project. You're in the line of where we're going to be putting the pipeline, for example. We are going to be looking at an easement on the property. Here's an offer. Will you just sign our easement? There's way more to it than that, but that's how it starts. And like I said before, my advice on this today really is don't panic and sign the first paper that they give you, right? You've got room to negotiate. You've got rights. There's an entire process set up in place for this purpose. You need to make sure you're aware of that and protect yourself. Okay, so it's sort of a four-step process. In our other courses, we walk through this in detail. The first thing is the offer. You'll get that initial written offer. It does have to be in writing. And the negotiating to sort of come up with, you can agree on the terms of an easement. And you absolutely should negotiate with these companies. Do not think you have to sign that first thing they give you. And they may say, well, if you don't sign this, we'll sue you. Fine. This is not the same kind of lawsuit as like, oh, I'm in trouble, I did something wrong. That's just part of the process for condemning property. So don't panic, right? You need to negotiate terms that are going to protect you. And we'll talk about where to get the idea of what some of those terms are here in just a minute. If the parties aren't able to reach an agreement as far as payment terms and things to protect the land, those sorts of issues, then there will be a condemnation filing. That filing cannot take place until at least 14 days after you receive a final written offer. And that final written offer is going to have to be 30 days after the initial offer. So what I'm saying here is you've got at least 44 days from the initial written offer to when the company can go and file that condemnation action. So again, don't let them pressure you into thinking you have to act immediately. You've got time. If a condemnation does get filed, you'll certainly get notice of that. It'll be in the county where the property is located. And what will happen first is that the judge is going to appoint 3 special commissioners. These are going to be local landowners. It's not your county commissioners. But the judge will appoint 3 local landowners, and those landowners will be tasked with holding an informal hearing where they will listen to evidence and they will determine the fair market value for the property. That's all they do. They don't figure out if the pipeline is a common carrier or not. They don't look at terms of an easement. They're just going to say, here's what we think the fair market value is for that property. Once that happens, either party has the right to object to the amount they came up with. The trial would then go to the trial court back before the judge. That's the point at which the landowner can challenge things like, do they have the right of eminent domain? Are they a common carrier, etc. And that's also where you can object to that special commissioner amount, and the parties can go have a trial about damages. And then if you don't agree with what the trial court does, there's the appellate process, as would be for any other case, to the Court of Appeals and potentially the Texas Supreme Court. So again, the takeaway from this, I hope that you're getting on eminent domain, is you have rights, and you should negotiate, and you should do everything you can to protect yourself and your property. If you want to read up on this, or if you get in a situation, a couple years from now, you're like, well, shoot, I didn't care about that back when I heard Tiffany talking, but I care now because here's the company. We've got a handbook that I did. It's called Eminent Domain, A Landowner's Guide. Texas Farm Bureau sponsored this. I wrote everything in the handbook. And it's just sort of, my goal is for it to be a guide that landowners can use. We walk through the law. We talk through the procedures, the process, how things will work. Then there's also a checklist in there for you to use if you're going to try to negotiate an easement. I will tell you that easements are something I definitely recommend you use an attorney for. There are a number of great landowner attorneys in the state that do a lot of work for Texas landowners dealing with easements. This is one of those places where I really think it's worth hiring an attorney to have them represent you and get you the best easement you can get. And one reason for that, right, is most of the time these easements are going to last for decades, if not longer, right? They may likely are going to last in perpetuity or have the potential to. We get stuck sometimes on the money, and the money's important. But keep in mind, right, that the terms of that easement are going to last far longer than that money you're going to get, right? You may have grandchildren or great-grandchildren who are dealing with the terms of the easement. And again, I just think getting one negotiated that best protects you is really important. So if you want to get a copy of this guide, we've got a free download on my website. I'm going to give you that information here in just a moment. You can also contact the Texas Farm Bureau. Your local office may be able to help. You may have to have them call the state office, but they will give out hard copies of this handbook. I think they charge like $1 or $2 just for shipping. But hopefully that's a resource that's helpful as you try to navigate this process. And finally, for our last topic, this is a fence law topic that I think is really important for landowners to be aware of. Are you located in a county that's open range or closed range? And I realize that if you don't know anything about fence law, that sounds like mumbo jumbo, and you may just think, open range, that was that movie with Kevin Costner. Yes, it was. But here's how this works, just some basic fence law info for you. So there are two approaches to fence law, and really which of these you're falling under is going to determine how you analyze almost any fence law question. And the issue is going to be, are you in an area that is open range or closed range? Okay, what does that mean? Open range generally means that the livestock owner has no obligation to fence his animals in or prevent them from running at large. Sometimes you call this a fence out area because it's going to be the obligation of the neighbor to fence out unwanted livestock, right? So generally no obligation on the part of the landowner. There are a few exceptions. We're not going to get into the weeds on that today, but just in general, if you're in an open range area, you have no legal obligation to fence your animals in. Closed range is the opposite. We sometimes call this a fence-in area because landowners do have a legal duty to fence their livestock in. Okay, so you've got to prevent them from running at large. All right, so which is Texas? Well, that's a more complicated question than you might think. The general rule, kind of our starting point, is that Texas is an open range state. That's true of most of the West. And again, what that means is our starting point says no legal obligation for a landowner to fence their animals in. However, it gets tricky because there are sort of two exceptions to this general rule. Two scenarios where that rule has been modified that actually make most of the state closed range instead of open. Now, there are some places that are still open range, but like I say, most are now closed range because of these two rules. The first is called the State and U.S. Highway Exception. You can find this in the Texas Agriculture Code. It applies statewide. And what it says is that all state and U.S. highways are closed range, and a landowner cannot knowingly permit the animals to run at large. So the way the statute defines state or U.S. highway, that's going to be, interstates like I-45 or I-40. That's going to be county road, not county roads. That's going to be state highways with a number on them, right? Like Highway 287 or Highway 60. It's not going to include county roads, and it does not include farm-to-market roads. That's just how that's defined in the statute. So this exception is not applicable to county roads or farm-to-market roads. But if you're on a state or U.S. highway, it's closed range, right? And again, your obligation is you cannot knowingly permit your animals to run at large. If you do, right, if your animal gets out on I-45 and gets hit by a truck, the legal question is going to be, did you knowingly permit the animal to run at large? You're not automatically liable, only if the facts show you knowingly permitted that. Okay, and so we've seen cases where, somebody knew that they had bad fences, knew the fences failed when it rained, got a call, that the animals were out one night and they didn't do anything to go deal with it. Cattle get hit the next morning. Those are facts that look like you knowingly permitted the animal to run at large, right? If you kind of contrast that with the case where you've got somebody who's never had cattle out before, they've got good fences, they didn't know the cattle were out at all, something got hit, that's where you're probably going to have a scenario where a court's going to say, look, it was a closed range area, but they didn't knowingly permit the animals to run at large, and so they're not liable. Okay, that's how that analysis works. So that's for all state and U.S. highways. The other exception is local stock laws. And so under Texas law, a county has the right to hold a local election to change all or part of the county from open range to closed range. If they do that, those statutes generally say that an owner may not permit their animals to run at large in the county. So that's what you got to figure out, right, is does your county, or specifically the part of the county where your land is located, does that have a local stock law? So how do we find that out? Well, once again, trickier than you might think. These local stock laws, like I said, are passed by election of local landowners. They're going to be published in the county commissioner records. And most of them were passed way back in the early 1900s. And so if you go digging through commissioner records, you'll see the scrawl handwriting before reporting the election results sometime. Before you start digging through commissioner court minutes, I would talk to your county sheriff, your county judge, county clerk, county attorney. I'd ask your county agent, see if they have done the research before or if they can help you do it now, because that's just going to be the easiest way to come across these. I am currently working with a law firm down in South Texas on trying to compile as many of these as we can. We hope at some point to open a website where you can just click and find your law. That doesn't exist yet. This is kind of the best we have to offer you. You have to kind of do your homework. Again, I'd start with those folks, see if they have it. If they don't have it or don't know, you'd have to go digging in those commissioner court records. There is a strange provision in the Texas statute, the Agriculture Code, that says there are certain counties that cannot be closed range for cattle. In other words, I'm going to put these counties up. If you are in one of these counties listed, you are open range for cattle because you can't be anything else. All right? You may be closed range for other species, but for cattle, you're going to be open range if you're in one of those counties. You may be able to cheat a little bit if you fall in that one of these areas. Okay, so with that, I'm going to kind of wrap it up here. I do want to mention a few other programs that I hope to be having. I'll tell you now that these live programs through the end of 2020, I think, are still pretty iffy. Right now, we still have them on the books. It's our hope that we're in a situation where we can hold them. That may or may not happen. But for now, we have our Owning Your Piece of Texas course, which is essentially just a 6-hour version of what we did today. We cover things in way more depth. We cover more topics like water law, special use tax valuation, different things like that. We're going to be in Burnet on September 15th. We're going to be in Seguin on October 7th. That class costs $75. You do get a hard copy of our Owning Your Piece of Texas handbook. With that, if you're interested, you can register online. The website is there on the slide. Another class that we have is called the Ranchers Leasing Workshops. These cost $50 in person. We're going to be in Fredericksburg, Abilene, and Fleming, hopefully. And so again, if you want to register, there is the information. We are also gearing up and offering some online courses. This has been really fun. Our Ranchers Leasing Workshop online course is available now. It's about 3 hours worth of material on ag leases, really focused on grazing and hunting leases. So if you're interested in that, it's a great course. You can watch, from the comfort of your couch at your own pace. You can pick the sections you want to listen to. You can re-listen to sections if you want to. It's going to be me standing in a room next to a slide, projector, just presenting like I would at a program. So if you're interested in that, there's the website. The cost there is $75 for that course. And as I mentioned, we are working now on our Owning Your Piece of Texas course. I hope to record those segments of video in August, and we're hoping to have that rolled out by the end of the year. That's going to be a jam-packed course of about 12 or 13 hours of information. We may also have an option for you to just purchase certain topics if you don't want the entire course. So just stay tuned if you're interested in that. It'll be coming. The best place to watch for things I have going on, like handbooks that I publish or news that's coming about ag law or the online course, is my website. You can just go to Texas Agriculture Law blog. The address is there at the top, agrilife.org/TexasAgLaw. That's where I post everything that I do. I post every week about a different ag law issue. There are also archives there of prior webinars I've done, published materials, etc. When you go, I know it's annoying, but there's a little pop-up box that's going to ask for your email address. If you want to subscribe, just put your email address there, click subscribe. What that'll do is every post I do comes to you just like an email from me. It'll only be once or twice a week. I will not spam you, but that way you don't have to remember to go back and look at that website. Okay, the other resource that I'll mention is our podcast. It's called Ag Law in the Field. If you're a podcast listener, we're on iTunes, your podcast app, Stitcher, Google Play, all the places. Just look for Ag Law in the Field. If none of that made any sense to you, you can just go online. We are at aglaw.libsyn.com. If you go to that website, what you're going to find is a list of about 85 interviews I've done with ag lawyers on different topics. We've done everything from water law to fence law to estate planning and kind of everything in between. It's audio only, so you can just listen to us. All you have to do is scroll down and find the topic you want and push play. You can listen to those. So with that, this last slide's got my contact information. Right now, with this kind of still being closed and our status up in the air, email is the best way to get a hold of me. Again, there's the blog and the podcast. I'm on Facebook and Twitter as well. So if you are on social media, feel free to follow me there. So with that, I will wrap it up. I thank you guys again for the opportunity to be with you today. If you have questions about anything we covered or any other ag law topic, please feel free to contact me. I'd sure be glad to help and point you in the right direction as best I can.
Did anybody have any questions while Casey's getting the next slide up?
Okay. All right, Miss Christie, are you still on with us?
Here.
Okay.
Can you hear me?
Yes, ma'am, I can hear you. Now, you told me you don't have a presentation, right?
I do not have a presentation.
Okay.
And I apologize.
No worries. Just wanted to make sure that was still it. So everybody, this is Miss Christie Oates. She's a district conservationist out of the Cooper office up there in Delta County. So Christie, if you want to explain a little more who you are and then go ahead and give your presentation. And I've got the NRCS website that I just pulled up. So if anybody has questions about that.
Great. So like you said, I am actually stationed in Delta County, but I am also operating the Clarksville field office at the present because district conservationist there got another job, and so I'm filling in for her, and that's in Red River County. The NRCS was originally organized as the Soil Erosion Service in 1933, and it was due to the Dust Bowl. So our basic goal is we offer financial and technical assistance to agricultural producers to promote agricultural production and environmental quality. Like I said, we do offer technical assistance, but we also have some programs that most of our farmers and ranchers are using or utilizing in some capacity nowadays. And if you don't know how to get set up in the system, Morgan with the Farm Service Agency, she could have told you, and I can tell you also, if you have a farm and you are not registered with the Farm Service Agency, that is the first step that you need to take. And what you do is you take your deed to the Farm Service Agency in your county or call them and set up an appointment to go there. And they will actually put that farm in your name and give you a farm number and a tract number, and then set up your eligibility requirements. So that's the first thing you do if you want to participate in any government program, just about our programs or their. So in order to sign up for anything, that's what you'd have to do first. We have 3 basic cost share programs that we, most of our producers like. One of them is the Environmental Quality Incentives Program. It's a continuous sign up. There's no minimum or maximum acres, and there's no caps to restrict participation. And EQIP offers financial and technical assistance to ag producers. The average non-farm adjusted gross income has to be less than $900,000 for conservation programs. So that's one of the forms that you'll fill out when you go to FSA. Some of the practices that we offer under EQIP is like cross fencing to facilitate rotational grazing, ponds for livestock water, grass planting, terraces, waterways, brush management. There's just a number of practices that you can sign up for under that program. The other program is the Conservation Stewardship Program. And it's more, we call it like the cream of the crop program. We suggest that you sign up for EQIP if you need to do anything. If you need to plant grass, if you need to build a pond, if you need to do cross fencing, if you need to do any kind of improvement on your place, sign up for EQIP first. And then once you've gotten all of your improvements done, then you would sign up for CESP, which is the Conservation Stewardship Program. And that is encouraging farmers and ranchers to maintain and improve conservation treatments that are already on their land. So that program is a continuous sign up also. It does have one funding period throughout the year, so you kind of hit and miss with that one, but it's still something that a lot of people are interested in. The other one is an easement program, and it's the Wetland Reserve easement. You can do a 30-year easement, a 15-year easement, or a perpetual easement. And that's for people who have hydric wetland soils. So that's not for everybody. And it's kind of, if you have a place that's swampy, boggy, that was trees at one time prior to 1985, but it's no longer trees now, and has been converted to some kind of cropland or pasture land, then it might qualify for the WRE program. So I didn't really prepare anything for tonight. I feel very unprepared after that last presentation, but like she said, I will give you my phone number and email, and y'all can call, or there's every county.
Thanks, Christy. I think that will be helpful. If I go to the NRCS website right quick, let's see if it'll let me.
Okay.
It's trying to. How about I just go to it myself? Man. Okay, is there somewhere on here where they can go to like look at those 3 different programs or learn more about?
You can either go into programs or go into financial.
Okay, so y'all see there's programs here. Yeah.
Any of the Farm Bill programs was talked about.
Okay. So yeah, so guys, anything, it's nrcs.usda.gov, and then programs and Farm Bill, and then anything under that tab. So I know these websites are a little complicated. Seems like all government websites are more complicated to use. So you really just have to play around and click until you find what you need. But there's some of the programs listed there. So if any of y'all had more questions, you want to go do some research.
Right.
Hey, Christy, we have one question on the chat board. Where do you go to seek assistance to build a pond?
To our office.
Okay. And then I got another question also. For down here in the county, I know a lot of people look to get assistance for like planting longleaf pines. They do that in your office also. That would be like the different stuff, right?
There's a huge echo.
So, Chrissy, he was asking about if there's a lot of people who want to get assistance on planting longleaf pines. Is that something they go through your office? Is that through the EQIP program?
Yes, it is.
Okay. All right, and then let's see. I think that's it. Let's see if there's any others. Okay. Oh, the question about where to build a pond. Our program on July 28th is going to be specifically over pond construction, pond health. So, Jason, you'll get some more information on that day. And we actually have another representative from the NRCS who specializes in pond construction. So there'll be more information on that to come. All right, Christy, well, I will, if you want to, either way, if you want to type your information in the chat box for everybody to see, your email, phone number, all that, or I can share it later.
Sure, I'll copy it in.
Okay. And with that, we will continue on. So the last two, I love how it starts at the beginning. Sorry, guys. Okay. All right, so the last two sections, we're going to talk about Farm Service Agency and, of course, Extension. Now, Morgan is our program technician in Wood County, and I believe their area stretches a little more than just Wood County. But unfortunately, they are no longer able to, I guess, promote programs or basically come and talk tonight, even though it was virtual. She said she wasn't going to be allowed to do that, but she did send some information, and I'm sure Christy probably covered the bulk of it anyways. But I'm just going to go through what Morgan sent me. So Farm Service Agency serves all farmers and ranchers through the delivery of effective, efficient agricultural programs for all Americans. Some of the big programs they're working on right now, of course, the CFAP, Coronavirus Food Assistance Program, which is offering financial assistance per head. Of course, it requires an application, an appointment with your FSA representative. And like Chrissy said, there are representatives for each, just about every county. For here in Northeast Texas, the office in Titus County serves Franklin, Titus, and Camp County. It may even serve Morris County. I'm not 100% sure. So that's the biggest thing, is just looking up where your local office is and then making that appointment. So another program that they've got is drought assistance, and that's actually called the LFP. Let's see here, which stands for something that I don't remember. I apologize. Sorry. Go ahead.
Livestock Forage Program, I believe.
Yeah, thank you. Thank you. Livestock Forage Program. That's correct. And so again, there's an application for that. You know, you've got to make sure you qualify, and it's a lot of steps. It's a lot of processes to go through, but I'm telling y'all, these services are your friends. You know, there's a lot of details, a lot of things you have to follow, but if it's something that you qualify for, I highly recommend taking advantage of it. So what I wanted to click on here, if it will work for me, for the CFAP. So the website here, farmers.gov/CFAP, if that's something you want to check into, you can actually apply online. You can print an application and turn it in. There's a few more things you can look at. You can see what crops or commodities are eligible. And again, just more information on that. Limitations, just everything on this website. And it's, since they've dedicated a whole website to it, it's a little bit easier to get through. But again, that was farmers.gov/CFAP. Now, someone called my office, it was probably a little over a month ago now, and all they said was, I heard the extension office is giving $33 a head for cattle. And I was like, man, I wish that were true. You know, I wish Extension had money to give. Well, I had no idea what that was in regards to. But it's actually part of this Farm Service Agency CFAP program. So I don't want to sit here and say you can get money for all your cattle, because I certainly don't know all the details at all. But it's something that you, let's see. So it's it's where you must call your office to sign up. Of course, you can apply online. The program ends August 29th. You will get paid up to $33 a head for cattle that you currently have or had as of May 14th. If you've sold anything, and of course this depends on, are they feeder cows or are they replacement cows? What are you using them for? So lots of hairy details in that. That's why I say I don't want to give too much information and be slightly incorrect or off. So if that's something you want to learn more about, please check out the website. Please talk to your local FSA rep. Because again, I don't want to be sharing something that's not exactly correct. But there is assistance out there, especially during COVID and what's going on right now. Okay, they also, so then LFP, let's go to that one for drought assistance. Okay, so livestock forage disaster program. This is just a little fact sheet, and I will send all of this to y'all. You know, I'll make sure everything that we talk about here is accessible to you. So again, you can get this fact sheet online. You just type in Farm Service Agency LFP fact sheet, and that should pull it up. But again, so you have to, your county has to be eligible for drought. It has to be, you know, one of these D2, D3, D4, you know, has to be considered one of those types of droughts. Again, I don't want to share a whole lot of information and be not completely accurate. And I don't want you to say, well, my extension agent said I can get money. And then you find out that's not exactly true. So again, we're just introducing these assistance opportunities, programs, and things. And if it's something that you think you might be interested in, go and check it out for yourself. Last thing, they actually have youth loans. So in my previous county, I had some youth who wanted to show livestock, wanted to get involved in the show industry and raising their own livestock. And so that's something else that they have. It's not well advertised. I know we have a fact sheet flyer here that I hand out if it's ever an issue, if money is an issue for kids being able to purchase their animals. But that's a really great opportunity as well if that's going to be something that you might be interested in. Okay. Yes, sir.
Can you, if I'm not echoing too bad, I'll add a few things.
Okay. I can hear you fine, but
okay, I was echoing real bad earlier.
Okay.
Two things on the FSA. One thing that Morgan didn't cover in Casey was they have a program called WIP, and I think it's Wildfire Hurricane Indemnity Program. And if y'all are down here in Polk County or towards my area, that helps a lot with flooding. So that's something I'll show. Might want to look into. We get a lot of floods down here. Something I want.
Yes, and again, like there's probably more programs, lots more programs than what we've mentioned. So just check out their website, talk to your FSA rep, you know, maybe just kind of explain to them what your goals are, what your property is, and see what might be available to you.
Mm-hmm.
And we've got somebody asking if Christy would share her email address. If Christy's already hopped off, I can share it in the chat box in just a little while. But okay, well, moving on to the last thing we wanted to talk about. Of course, y'all know Extension because you're here. So you know who we are. You know you have a county extension agent in just about every county. And so I just wanted to highlight some of the big things that we do. And of course, Matt can tell you all other details too. But basically, we've got Extension has agriculture and natural resources. Within that, it's even got horticulture. Horticulture. Sorry, we've got ag agents, horticulture agents. We've got our 4-H and youth development, and then we've got our family and community health, which are our FCH agents. So in the larger counties, you might have an agent for each one of those topics. In the smaller counties, you might just have 1 or 2 agents. So, but basically what I do, which is, it's kind of hard to give a short answer, I guess you could say, but we provide research and education. We're providing that education tonight with this program. Of course, we're also here to answer all those common and uncommon questions. I've done lots of plant identification this week, and then, we also get that jar of bugs sitting on our desk that we have to identify on occasion. We also provide the trainings for pesticide applicator license holders to maintain their license, and so we provide those through continuing education units. So anytime you see a program that says it has a CEU, that's most likely going to be for your pesticide applicators, the ones who already have their license. We also provide that training for those of you who will need to obtain your license. So you have to apply for it, you have to take a test. We provide the training for you to prepare for that test, basically. Then here recently, I think all the agents have probably been introduced more than we would like to emergency management. So that's just something, I want to highlight that all of us agents have been real busy during this COVID time. We have been some of the ones making sure PPE equipment has been delivered to our schools and childcare facilities. So that's just something else to keep in mind. We have various different hats that we wear. Matt, if you want to touch on anything else.
Yeah, I can if it doesn't echo too bad, which it is.
I don't know. I can hear you fine. I guess that could be other
Okay, I don't know.
But
Maybe it's just on mine. I say a lot of times that our job is kind of 30% answering calls and going out and doing site visits and visiting with people, just people coming into the office. The other 30% is putting on programs in areas that are of interest to our county. So here in Polk County, beef and forage is one area we do a lot of programs in, and then in forestry and wildlife, we're a big timber county. And then the other 30% is just anything like emergency management, anything at the state or the county level wants us to do. So like, for me, first, in the last month we worked with tornado with the response. Was busy there. And then the last percentage is just oddball stuff to think of.
Right, yeah, the oddball stuff we always get, and I welcome those. It's kind of like if you don't know who to call, let's call the county agent. She'll know. And that's, I usually try to know. If I can't help you, I try to figure out where to send you. So not everybody may go to those links, but I try to for y'all. The next thing I've got up on the screen, just some of our websites. Of course, I put mine because I'm in Kent County, but the first one, our main agrilifeextension.tmu.edu. You can go there to find anything going on at the state level for extension. And then every county has their own web page. So where it says camp in there, type in anycounty.agrilife.org, and that will pull up your specific county. Then social media, that has been, I accidentally clicked on it. Let's see if it might pull it up. So social media, just about everybody, every county may have their own page. You're welcome to follow mine. And then, of course, I try to highlight other local counties around me and share anything that may be relevant, to the Northeast Texas, East Texas general area. So that's one thing there. And then lastly, I do have a YouTube channel. Matt has a YouTube channel. And I've shared some of his stuff before on my page, so you should be able to find either of us relatively easily. But here's the YouTube channel. It's Life of an Ag Agent. Matt, what's your page called?
AgriLife Extension Polk County.
Okay, AgriLife Extension Polk County. So.
Or Polk County AgriLife Extension, one way or the other.
Okay. Yeah. So anyways, we're posting or trying to post a lot of our videos for our programs that we've done like this up there. So if it's something you weren't able to watch live, you can almost always go and watch it there, watch the playback